Issues of the Nigerian Bar Association politics, the anti-graft war, and the propriety of the courts going on vacation form the core of our conversation with Senior Advocate of Nigeria, Robert Clark. We also look at calls for the cancellation and suggestions for electoral reforms, which still trail the outcome of the recently concluded NBA elections, plus our recap of the top trending stories from the courtrooms. That's our lineup on this episode of the program. Hello and welcome. I'm Shola Shieli. My guest, Robert Clark, SAN, needs no introduction. He's always been very vocal about issues concerning the bar and the bench, giving suggestions and directions on how he thinks things can work better. In this interview, I sought his views first on the NBA elections and how the bar in future can avoid a situation where the outcome of its elections are always trailed by allegations of rigging, especially because this time he publicly endorsed a presidential candidate.
Yes, I agree. I supported one of the three candidates from the considered view that he has been exposed so much to the bar politics. And despite and in spite of that, I have no reservations about the new man who has been, because he also is a capable man to head the organization or the association. However, one has to note one fact, that the Bar Association, being a lawyers' forum, also has political connotations. If anybody says politics is not part of the Bar Association's election, then he must be living in a fool's paradise. It's got to the stage, which I know, that state governors even sponsor presidential or candidates in the Bar Association. So where you find politics and politicians coming to have a hand in an election, definitely, going by their own history, they always rig, and they believe anything can go. So if one of the candidates feels that there was a rigging of a nature that he can prove, because for me personally, I always believe that it is better to be sued or taken to court than you taking. For instance, I have a very senior advocate of mine. He will never, in an election petition, act for the respondent, for the petitioner. He will always act for the respondent, because you cannot prove illegalities, you cannot prove malpractices in an election petition.
Why? Why is it so difficult to prove?
Look, the standard of proof is that whatever INEC has done under the law of evidence law is correct. So for you to challenge it, you have to show, and it's difficult. Whereas if the doctrine has been changed, that INEC should be regarded to come forward to show that they effectively conducted a fair election, then it could have been better. But you see, in election petition, INEC will not even defend. They will say they are resting their case. So it's difficult to prove malpractices. Now, in the Bar Association, if a man says, oh, I was rigged out, and he can bring the specific areas, good luck to him. But I can't see anything coming out of it. I can't see anything.
Mm-hmm. But what is it about the Bar Association and its presidency that is attractive to politicians? Because you just told us that politicians have taken an interest in, and they are sponsoring candidates for positions in the Bar Association, especially the presidency. What is it about the bar and its presidency? Why is it so powerful?
You see, the generality of people adore the profession of lawyers. The generality of people, when they come to court and they see the way lawyers are dressed and judges are dressed, give an aura of respectability. So, right from ages, lawyers have been placed in a high pedestal by the common man. Now, also, in a society that is ruled by law, lawyers have a larger percentage of, reflecting the society more than any other profession. Lawyers also, for instance, in America, 60% of the Congress in America are made up of lawyers. In Nigeria also, there are many lawyers who are governors, who are this. So you can see that the prestige attached to the profession, not to the individuals who make up, but to the profession itself, has given the bar a form of a higher pedestal than is necessary. Therefore, there is no doubt, because lawyers can influence the society and can speak for the society, they are placed in a higher place, and that's why we have that aura surrounding us.
And that's why politicians continue to take interest in,
Definitely.
in the elections. There are many lawyers, many people, lawyers inclusive, who say that the NBA is not living up to its role, especially to the public and even to its members. So as a sort of agenda setting for the new leadership that is coming in, what would you say that it should focus on, especially in living up to its role of being the voice of society?
Now, let me be honest. I do not see the foreseeable future that the Bar Association will isolate itself from politics and decide to be the citadel for the oppressed or for the voice of the people. I don't see it, because politics has come into it. Now, when politicians surround you, they bring the money. If you know how much I have been told that this candidate spent in asking for his so huge a money, I've never seen it in my life. And that's how much they have thrown around to be elected. And most of them rely on these politicians who have access to easy money. Now, he who plays the pipe, dictates the tune. So once you become, and you are an opposition to the governing party in the federation, and you want to criticize that party, you use this, and they tend to be used, and they get themselves to be used. Therefore, the focus that you are looking forward to objectively is no longer there. Most of them subjectively toe the line of their sponsors. And therefore, I don't see in the foreseeable future that this thing will change until the system of governance itself in Nigeria is changed. And then maybe we can kowtow into that change. But as of now, I don't see any change coming.
That's a sad commentary, really, because I would have thought it takes just one individual to make a change.
Well, in any society, it takes an individual. But that individual must be on top of that society to have it meaningful. For instance, you cannot change society except by revolution from the base. But a true leader in a country can change the society, and the society will accept it if, by example, he shows that he is correct. My advice is that we should jettison the 1999 Constitution, which gives absolute power to a governor, gives absolute power to a president, so that if you are not in terms with the governor, you cannot make any effort in your state. If you are not in terms with the president, you cannot have a go forward in your exploitations. So I believe that we should change our system of governance. If we change it and we find right people who will now come and serve, not because of the stupendous money. Many people don't know that immediately a new National Assembly is constituted, all the banks rush to them, offering them 100 million loans, repayable in 4 years. You can see that's where corruption starts. I was hearing on your channels one ex-member who said the first thing when he was entering the house was to be given a form to be filled by the banks. So you can see that the system is corrupt. A good leader cannot emerge from that corruption.
Since you've talked about corruption now, let's move on to the anti-graft war of this present administration. Do you support a call for the total overhaul of the fight against corruption, especially given recent developments? We see that the chairman of the EFCC has been suspended, talking about Brian Mago. We see the rot that is going on with the NDDC probe. Do you think that it's time for an overhaul of the anti-graft war?
You see, it's not possible to do an overhaul within the same system we're operating. It is so disheartening to find the allegations coming out in NDDC. But it has been going on for years. And it is the system that permits it. So even if a president comes, I want to fight. Buhari is fighting corruption, but many of his cronies are enmeshed in corruption, which because the system allows them. Why should you be giving money that was meant to resuscitate the people in a particular area. You are giving it to national election people to use for contract. You see, it's the system. So before you can fight a meaningful fight against corruption, you must change the system that allows it to happen.
I want us to talk about the loan agreements between the federal government of Nigeria and the government of China. It has been called into question by some people because of the controversial clause which seems to waive part of the country's immunity. Talk to us about the legal and the diplomatic implications of this.
You see, before 1976, you cannot sue any government, even if it does commercial practice. They always come around to say, oh, when you sue them, they declare sovereign immunity. Nigeria was the first country in the whole world to change that concept. During Mulitala's regime, Mulitala ordered cement from overseas, and we had what we had, cement armada in Lagos port, where demurrage was being paid for 50 days, 30 days. When Nigeria was sued, they raised this doctrine of sovereign immunity. And the International Court said, no. Once a government that has the sole responsibility of governing decides to go into commerce, then it can no longer use that sovereign immunity for commercial businesses. Therefore, I remember in 1977, I went for a course in America, 3 months, and I was with a group of lawyers. And I was invited. Gabon then was applying for a loan from, I think, Morgan Guarantee. And we all sat down because my portfolio then was with Icon Merchant Bankers. And we know how to put default clauses in loan agreement. So when we were arguing, it was suggested amongst ourselves that, look, any government that decides to now go into a commercial war and ask for a loan, you should have a defaulting clause that you agree that in the event of a default, you will not exercise your sovereign immunity. So that is that clause, and it's an international clause now. And that is that clause in this agreement, that if Nigeria does not pay, and Nigeria is sued, they cannot rely on sovereign. So they have relinquished that right to use. So there's nothing extraordinary about it. I'm shocked that many responsible Nigerians in the House, and even the former Vice President, are shouting without looking properly for advice on that clause.
So there's nothing untoward.
There's nothing funny, there's nothing detrimental to the country. It's only that when you default, don't come and tell us, oh, you are a sovereign country.
You have immunity.
Okay. So better deny yourself that right in that agreement.
Finally, let's come back to the profession and round up with this issue of the courts. Some of them have proceeded on vacation, and there are people who are saying that this is wrong, that because we had a period when the pandemic shut down the courts except for urgent matters, and so the courts were on some kind of forced holiday. For the judges to now say they are proceeding on vacation after coming from that first holiday which the pandemic imposed on us, that it is wrong for them to say they now want to go on vacation, that they owe Nigerians, the society, a duty to continue to stay and administer law and order in the society, and that there's no need for a vacation. What do you think?
You see, it depends on which divide you are. There are two sides to this matter. If you agree that most of our courts are overworked, there are too many cases, and most times you spend 6, 7, 8 years in the lower court to finalize a case. You spend 12 years in the Supreme Court for an appeal to be heard. So these courts are being overworked. And now that period of the lockdown enabled many of these judges who had judgments to sit down to write the judgment. So you can see that they are not on vacation because of the lockdown. They are still fulfilling their judicial functions. So that now, if any judge stands up to say, oh, my judgment is not ready, then you know that it's a lazy judge. Therefore, if you look at it from that angle, you cannot blame them.
For wanting to go on vacation.
Because writing judgment itself is a very tedious work. So I give it to them. So I am not in that group that says, oh, therefore, I give it to them, allow them to go and rest. Because That period was also a period of meeting up all the background of work.
All the backlog that was pending.
Oh, yes.
Welcome back. Now let's look at some more of the fallouts from the just concluded elections of the Nigerian Bar Association. On Monday, the 3rd of August, one of the presidential candidates, Dele Adesina SAN, asked the body of trustees of the NBA to cancel the just concluded polls. In his 11-page petition to the body, Mr. Adesina described the elections as electronic fraud, illegal, and unconstitutional. In a similar vein, the Southwest Lawyers Forum, popularly known as Egbe Amofin, also rejected the results of the elections, alleging manipulation. Reactions have continued to trail these calls. While Mr. Adesina's campaign manager believes the election cannot stand, another contestant who took part in the polls believes that calling for cancellation is not the best.
The Constitution actually presumes that the election will be held at branches. The Constitution provided that branches should be provided with adequate infrastructure for the conduct of the election. But what we are having now is an online-based election that is too prone to manipulation. So what we had in the last election was an election that was flawed ab initio. The preconditions were not satisfied, and if you have an election that you did not meet up with the condition for the background for going into that election, then it's very clear. Service of lawyers are being secured by politicians or other people to defend them and also ensure they get justice as a sort of either manipulated election or undue exclusion or the flawed process in any election, both the political parties and other associations. How come the lawyer association cannot on their own do the same? And if they have done something wrong, so how come it will become difficult for lawyers to also seek redress that this process was wrong and let us do it the right way? As it is, the proper thing has not been done. The precondition has not been met, was not met, and we went into the election in such a terribly managed and badly managed process. So that naturally will lead to the call for review of that process and probably the nullification of the election. And that's why it is not just about Dele Adesina. The Egbe Amofin, whose candidate was in that election, and that is Dele Adesina, came up to say that they did not believe legitimacy of the process, and they feel that this election cannot stand the test of time and should be appropriately nullified.
I actually agree with the position of Egbe on the just concluded NBA elections. What I do not agree with is the calls for cancellation of the elections. Yes, it was flawed. Yes, there are a lot of questions to be answered, but I believe we can answer those questions. We can look at those problems and we can start fixing it. Canceling the election is not going to be a solution, because if you're canceling it, then we have to completely review the entire process. This may take months, and right now our nation is in a position where we need defined leadership and not just leadership that is holding forth for the substantial leadership. So at this moment, I'd encouraged Egbe Amofin leadership to consider putting in structures of ground, at least for the West, and consider engaging with lawyers in the West and doing other projects and other programs that will impact lawyers in the West. And at the same time, try to look at protocols for the incoming elections in 2022. Now, I believe that this is more productive is more productive for Egbe Amofin to embark upon than to be calling for the cancellations of the elections. So yes, we're not perfect in what we do, but we should aim towards perfection and do what is right for the moment. We should really think beyond ourselves and start thinking about the generation ahead of us. Because if we don't do that, we will just continue to live in the abject poverty of mind and economic and social degradation that is going on in this country right now.
And just before we go, here's a recap of some legal stories we're tracking.
We'll begin with the report that the Economic and Financial Crimes Commission, EFCC, has rearraigned a former Attorney General of the Federation and Minister of Justice, Mohammed Adoke, Senior Advocate of Nigeria, on an amended money laundering charge. He was rearraigned alongside a businessman, Aliyu Abubakar, before Justice Inyang Ekwo of the Federal High Court in Abuja. The case is one of the multiple charges the EFCC has filed in different courts in respect of various aspects of the controversial OPL 245 transactions, also known as Malibu Oil deal. In the amended charge, the number of counts increased from 7 to 14. At their arraignment, both men pleaded not guilty to the charge when it was read to them. Still in Abuja, the Court of Appeal has held that a former member of the House of Representatives, Mr. Farouk Lawan, has a case to answer and needs to defend the allegations in respect to the 500,000 bribery charges preferred against him by the federal government. A three-man panel of the Appellate Court unanimously affirmed the October 17, 2019 ruling of Justice Angela Otaluka of the High Court of the Federal Capital Territory, who had dismissed the no-case submission filed by Lawan. Justice Peter Ige, who read the lead judgment of the Court of Appeal, resolved all the four issues that Lawan raised in his appeal against him. After throwing out the appeal for lacking in merit, Justice Ige ordered Lawan to return to the FCT High Court to open his defense in the charges against him by the Office of the Attorney General of the Federation. In 2012, the AGF had alleged that while Lawan was chairman of the House of Representatives Ad Hoc Committee on Fuel Subsidy, he accepted a bribe of $500,000 to remove Xenon Petroleum and Gas Limited, belonging to billionaire businessman Mr. Femi Otedola, from the list of firms indicted by the committee over alleged fraud in the fuel subsidy scheme. In Lagos, the State Criminal Investigation and Intelligence Department of the Police Command has arraigned popular artist Azeez Fashola, popularly known as Naira Marley, and his manager Sheyi Awonuga before the State Special Offences Mobile Court, Oshodi, for violating the ban on interstate travels. The two pleaded guilty to the charge and were awarded a fine of 100,000 naira each by the presiding magistrate. The controversial artist left Lagos for the Federal Capital Territory for a concert which held at the Jabi Lake Mall, Abuja, on Saturday, June 13, 2020. The concert sparked public condemnation after footage of the fun seekers violating social distancing protocols while the city was on lockdown emerged on social media. Barely 24 hours after, an Abuja mobile court also ordered Naira Marley to pay another 200,000 naira fine for violating the COVID-19 protocols. During his trial at the Eagle Square, Abuja, Naira Marley again pleaded guilty, and the presiding magistrate, Idayat Akoni, ordered him to pay the sum of 200,000 naira fine. The magistrate further ordered him to publish a public apology in any of the national newspapers. The Federal High Court in Lagos has ordered the remand of a businessman, Ibegbu Anayo, who was charged with producing and distributing adulterated total and mobile automobile engine lubricants. The Standards Organization of Nigeria, SON, arraigned him before Justice Rilwan Aikawa on the 12-count charge of producing substandard engine oil after rebranding them. The judge ordered his remand in police custody pending the hearing of his bail application. SON says Anayo and others now at large on July 15, 2020 at Mami Market, Navy Town, Ojo, did indulge in the production of adulterated substandard total and mobile engine oil lubricant for public consumption. The product, SON said, did not also comply with the mandatory industrial standards for lubricant, an offence punishable under Section 26 Sub 2 of the SON Act 2015. And we round up with the report that the Kaduna State High Court has fixed September 29 to rule on the no-case submission filed by the embattled leader of the Islamic movement in Nigeria, Sheikh Ibrahim El-Zakzaki. The IMN leader is asking the court to quash the state government's case against him for lack of merit. Justice Gideon Kurada fixed the date after El Zakzaki's counsel asked the court to quash the charges for not disclosing an offense known to law against the client. The IMN leader and his wife, Zinat, are standing trial on allegations of culpable homicide, unlawful assembly and disruption of public peace, amongst other charges.
And here's where we adjourn till next week. Don't forget that you can watch again this episode of the program and past episodes on our YouTube channel. I'm Shola Shoyeli. Thank you for watching.